The Supreme Court justices had scheduled to deliver a ruling on 2 applications filed by Robert Kasibante, one seeking access to data from the biometric voter verification kits held by the Electoral Commission and seeking evidence from President Yoweri Kaguta Museveni. Court also expected to rule on Kasibante's request to cross-examine the Electoral Commission chairperson and the Deputy Attorney General, Jackson Kafuzi. However, despite all parties appearing in court, the respondents were taken by surprise when Kasibante, through his legal team, revealed that he had already filed an application seeking to withdraw the petition.
So we are saying we wrote letters which we are going to share with you to all political parties to have evidence, to support us with evidence in that area. But most of them were adamant, but they did not all support us. And we said no. And we saw where we are going in this money, which we didn't have.
Kasibante explained that prosecuting the petition will require him more than $5 million and navigating complex legal procedures, which he said he could no longer sustain.
Now, this case, to petition a case in a Supreme Court, you need like a $3 billion. I sold all what I had to have this case filed here. Now, adding more $4 billion, that means I'm going to be announced a bankruptcy.
He therefore asked the Supreme Court to grant him permission to withdraw the petition. Following the development, proceedings could not continue. The justice held a 15-minute cross-door meeting with all parties, after which the Attorney General Chiwanuka addressed the media.
Everything that is done here in election petition is done very fast. So once the court tells you we're waiting, the court requires us to file our responses, and we're going to file responses immediately. As you may realize, we filed opposing the application, we filed opposing the petition. So from the Attorney General's part, we don't intend to oppose.
Oh, wow. Okay.
The Attorney General expressed disappointment, citing that time and resources already expended by the respondents.
Of course, we put in a lot of time and work. We were ready for the hearing. If you were here the last time, we did make our arguments on the application. We filed voluminous responses to the application. So yes, we obviously will be affected.
The Electoral Commission's lead lawyer, Kaguta, said he was not surprised by the move, arguing that the petition lacked merit from the outset.
We're not happy because we put in a lot of time. Then as lawyers, we had expected the precedent because we had guided the court in our submissions on how to treat this application. And if this Supreme Court pronounced itself on the matter.
Other political actors approached him and promised to back him up. Unfortunately, he was left hanging in balance. He was smart enough. And he said, no, I have to do what? Maybe I have to withdraw. Because you guys, you are going to incur costs, of which costs, I don't know who would have bailed you out.
Kasibante, however, vowed to chant a new source of action following the withdrawal of the petition.
Phase 1 ewedde, tugenda mu phase 2. Enendemeredde. Betwakisuubira nti bagenda kunnyambako. Kakati ngenda ku kyakubiri kyeseetaaga bannayuganda kunnyambako okuggyako abo abakkiriza mu byenkola ki byenzikirizaamu. Mwami Kyagulanyi gobeera eyo nange ngenda kubeera eno.
If formal responses are filed, the Supreme Court justices are expected to resume hearing next week to give further directions. In his main petition, Robert Kasibante had asked the Supreme Court justices to nullify President Museveni's election, citing alleged election irregularities, voter bribery, security agency involvement, and claims that voting took place in more than 15,000 non-gazetted polling stations. Deborah Namamonde, Viola Nansubuga, UBC News.